Hello everyone. Today's topic is company meetings. This is the first part of company meetings. In this video, I am going to share with you the definition, meaning, and requisites of a valid meeting. Let us first discuss definition and meaning of meeting. A meeting is a gathering or assembly of two or more persons for transacting any lawful purpose. In the case of Sharpe versus Davis, 1876, it was held that the meeting is an assembly of people for lawful purpose or the coming together of at least two persons for any lawful purpose. The business of the company is carried on by the selected representatives of the members called the directors. They take decisions by calling their meetings. There are some other matters which have to be decided by the whole body of shareholders of the company. They call their meeting to decide the matters. Now we move on to the topic requisites of a valid meeting. Requisites means essentials of a valid meeting. The first essential of a valid meeting is that meeting must be convened by proper authority. Convened means called. The board of directors has the power to convene every type of general meeting of the members of the company. A decision to call an annual general meeting must be first taken in the meeting of the board of directors. Sometimes a requisition to the board of directors to call a general meeting is made by the members. Requisition means demand, and in some cases the tribunal may call or direct the calling of annual general meeting. The second requisite of a valid meeting is proper notice. A proper notice should be given to every member of the company, nominee or legal representative of deceased member, the auditor or auditors of the company, the official assignee of the insolvent member, every director of the company. The notice should be given 21 clear days before the date of the meeting. But a meeting can also be called by giving a shorter notice, that is, notice of less than 21 days. If consent is given in writing or by electronic mode by not less than 95% of the members entitled to vote at such meeting. The notice should be in writing or through electronic mode. Now we move on to the third essential of a valid meeting, that is contents of notice. Every notice of every meeting must specify the place or venue of the meeting, the date of the meeting, the day of the meeting, the hour or time of the meeting, agenda of the meeting. Agenda means things to be done, and the nature of the meeting. The notice shall be accompanied by an attendance slip and a proxy form with clear instructions for filing, stamping, signing, or depositing the proxy form. The fourth essential is quorum for meeting. Quorum means the minimum number of members that must be present at a meeting for transacting its business. Section 103 of the Companies Act 2013 contains the provisions relating to quorum. This section says that in case of a public company, the quorum shall be If the number of members as on the date of the meeting is not more than 1000, 5 members shall be the quorum. If it is between 1000 to 5000, then 15 members shall be the quorum. If the number of members exceed 5000, then 30 members shall be the quorum. In case of a private company, 2 members personally present shall be the quorum for a meeting of the company. Generally, the quorum is fixed by the Articles of Association of the company, but the articles cannot provide for a smaller quorum than the above. For the purpose of quorum, only the members personally present are counted, and no proxy shall be counted. The quorum must be present when a general meeting of a company proceeds to transact its business. If the quorum is not present within half an hour from the time fixed for holding a meeting of the company, the meeting shall stand adjourned. Adjourned means postponed to the same day in the next week at the same time and place. In case the meeting is called on the requisition of the members, if the quorum is not present within half an hour, it shall stand cancelled. The fifth essential of a valid meeting is chairman of the meeting. A chairman is a person who presides over the meeting. He is a person who regulates, controls, and directs the smooth conduct of the business of the meeting. The appointment of the chairman is usually regulated by the Articles of Association of the company. But if nothing is provided in the articles, the members personally present at the meeting shall elect one of themselves to be the chairman of the meeting. The chairman must preserve order in the meeting. He must conduct the meeting in a fair and impartial manner. He must ensure that the meeting is duly constituted in accordance with the Companies Act and the Articles of Association. He must give a fair opportunity to members to discuss any proposed resolution. The next essential of a valid meeting is voting at meetings. The provisions relating to voting are given in section 107, 108 and 109 of the Companies Act 2013. To reach a decision on the proposed resolution of the meeting, it is put to votes. The Companies Act recognizes the following methods of voting: voting by show of hands, voting through electronic means, and voting by poll. Next essential of a valid meeting is resolution. The provisions relating to resolutions are given in section 114 of the Companies Act 2013. The term resolution may be defined as the formal decision taken at a meeting on any proposal presented before it. If it is duly passed, it binds all the members of the company. The Companies Act provides 2 kinds of resolutions: ordinary resolution and special resolution. An ordinary resolution means a resolution which is passed at a general meeting by simple majority of the members. If the votes cast in favor of the resolution exceed the votes cast against it, the resolution is said to be passed by simple majority. A special resolution means a resolution passed in a general meeting by special majority of the members. Special majority means by the support of 3/4 majority of members present and entitled to vote at the meeting. The next essential of a valid meeting is minutes of meetings. The provisions relating to the minutes of meeting are provided in section 118 and 119 of the Companies Act 2013. The term minutes may be defined as a formal written record of the proceedings of a meeting which is either in physical or electronic form. Every company should keep books containing minutes of meetings of directors as well as of members. These are some essentials of a valid meeting. That's all for today. Thank you very much for watching.